Good morning, everybody. Thank you for joining us this morning. We are going to discuss wills. Our speaker is Professor Linda Schoeman, and obviously today is the 30th. Before I introduce Professor Linda, just one or two things quickly. The rules are we've muted everyone. Please keep yourself muted. Turn off your cameras. That will assist with the bandwidth. Ask your questions in the chat box. All the questions will be answered after the presentation, please. This presentation is being recorded. The link for the recording will be sent to you via email on your request, please. We're not going to send it to everybody. Not everybody would want it. So just send your request. And then any general questions about the webinar, please email to Charlene at Jan L Jordaan. Or even if you want your CPD points, FISA has been so kind to allocate 1.5 CPD points for this webinar. All right, let me quickly introduce our firm. We practice under the name of Jan L Jordaan Incorporated. You'll see there on the right-hand side, we're celebrating our 30th anniversary this year. We specialize in the administration of deceased estates, deceased estates property transfers. We do quite a bit of them, or that rather. We do wills. We don't charge for wills. You're welcome to contact us. We also conveyances. We do transfers, registration of bonds, cancellation of bonds. We're also on the panel of ABSA, FNB, Nedbank, and Standard Bank. We do ANC contracts, and we do trust. We assist with trust, the registration of trust, the cancellation of trust, amendment of trust, and then also very important, we act as independent trustees. Always welcome to contact us if you need, want to make use of our services. Now it's my privilege to introduce Professor Linda Schoeman. Professor Linda is currently an emeritus professor in the Department of Private Law in the Faculty of Law, University of Pretoria. She's an advocate of the High Court. She has lectured at under and postgraduate levels on the law of succession, administration of estates, and estate law of persons for 37 years. She's the co-author of the textbook Law of Succession and Deceased Estates, currently in their 5th and 11th edition, respectively. She has published more than 50 peer-reviewed research articles on the broader field of the law of succession and administration of estates. She received the Teaching Excellence and Innovation Faculty of Law Award in 2014 and held a National Research Fund rating for 2 consecutive terms. She annually delivered papers at national and international conferences. Since her retirement, she has annually presented webinars for the Law Institute on a variety of topics regarding wills and the administration of estates. Professor, thank you so much for your time. We are really looking forward to what you're going to share with us. As we agreed, you will now take over and the control, and you will carry on. Professor Linda.
Thank you, and good morning, everybody.
Morning, Prof.
Nice to not see you, but to know that you are there. I've been asked to discuss a few topics with you today regarding wills in general, aspects of execution, and also the formulation of certain institutions in your will. So we will have a quick look at the requirements for a valid will, what caution should be taken when drafting a will, the content of the will, aspects of per capita and per stirpes, divisions, fideicomissum residuum, usufruct, and massing. Now, when we look at the slide, you will see that I refer you there to the statutory provisions regarding the formalities. Unfortunately, the formalities are not the only requirements for a will to be valid. Something that you, when you draft a will, should take into account is at first the question of testamentary capacity. of the testator. So you can apply with all the formalities, but if you do not have a testator who is able to understand the nature and effect of the testamentary act, it all goes up in nothing. The requirements, the statutory requirements are rather straightforward, and most of us know what they are and what you should do to comply with. It boils down to that the will must be signed at the end of the document by the testator in the presence of at least two competent witnesses, which must also sign in time after the testator. And then the testator must sign all the other pages, but it's no longer necessary for the witnesses to sign all the other pages. The only problem that we currently experience with Section 2.1 is that it is required that when somebody sign on your behalf, or when you sign the will by making a mark, that there must be a certificate attached to the will, but these requirements are not for the testator to comply with, they are for the Commissioner of Oaths to comply with. And quite a few of these Section 2.1A5 cases, you will find applications in terms of Section 2.3 for condonation for non-compliance, because it's quite a few requirements that the Commissioner of Oaths should take note of. The first case that was reported on somebody signed on behalf of the testator was in fact the case of Jus van der Westhuizen, where he was not able to sign according to his ex or estranged wife. He was able to sign, or at least to attach a finger mark, but it didn't happen. The attorney signed on behalf. There's no indication as to the instructions that go with that. So you cannot execute a will on behalf of somebody. At least the person must agree to the content and therefore the requirements in Section 2.1A5. Just remember that the same formalities apply when you want to amend your. Now, the amendment of a will is a bit uncertain as to when is it an amendment and when is it a partial revocation. Why I mention this is in case of a partial revocation, no formalities is required, while in case of an amendment, Section 2.1B applies, and you must comply with the formalities. Sign as close as possible to the amendment in the presence of two competent witnesses, and so forth. So, other than this, the formalities are clear, but for a lot of fraud and forgery that nowadays appears from time to time. You will remember that last week, Pia said that when a will does not comply with the formalities, that the will is invalid. In the past, there were quite a few absolute ridiculous little non-compliance aspects, and then a will was found to be invalid. Therefore, the Law Commission recommended the addition of a section to the Wills Act for cases where there were non-compliance. But the whole idea was to help people that their wills will be valid if there was just a little mistake, even if the mistake was made by the will drafter. But in fact, this Section 2.3 led to more confusion than there was ever before in the law of succession. Literally thousands of cases have been reported, and up to today, it's still sort of free for all. We have some guidelines, but it is rather you can take any word in that section, and there is a case on that specific word. So the will is invalid if it does not comply. But you can then bring an application for the condonation of the non-compliance. Now, the section reads that you can apply in case where there's non-compliance with section 2.1. Now, we've seen on the previous slide, section 2.1 deals with formalities, 2.1a, and amendments, 2.1b. Those are the only formalities that you can condone non-compliance, not you, the court, and only the court. There was also a case reported, why didn't the master accept this will that does not comply? But the master can't. The court is authorized to condone. So it means costs for the estate or for the person who wants to bring the application for the condonation as such. What we know is that in terms of, so you cannot apply, say, in terms of section 2.3, say, for instance, that the witness is also a beneficiary and wants to inherit. You can apply in terms of section 2.3. You will then have to bring an application in terms of section 4A of the Wills Act. So there are quite a few other sections in the will. You cannot bring an application in terms of section 2.3 for revocation of a will or methods of revocation. You can bring a 2.3 application if the court condones the will and there is a revocation clause in that condoned document. Then and only then will there be a revocation, because that is one of the common law ways of revocation. So remember, 2.3 only deals with section 2.1 of the Wills Act. And that is formalities for executing a will and formalities amending a will. Now, this section requires from before you can bring an application, that there should be a document. It can be any kind of document, even a cell phone message has been condoned in the past. Email has been condoned, a diary entry was condoned. There must be a document, but there must be writing, one or the other form of writing. This document must have been drafted or executed by, that's the question, whom? The appeal court of appeal ruled that the section reads that this document must have been drafted or executed by the person who had died since, meaning the testator himself. After Bakker versus Nordeer's case, there were quite a few other cases without even really referring to Bakker's case because it was wrong. It's not that the testator must draft or execute the will. Obviously, the testator must execute the will, but the practice is that attorneys or financial advisors or your neighbor is the person who drafts the will on your behalf, or yourself. It might be the testator, but it's not always the case. So then the Court of Appeal ruled that it is not necessary for the testator himself to draft or execute the will. but the testator must at least identify, there must be a personal connection. It means that somebody must have shown the will to, he must have approved the will, it must have been read to him, or one or other way in which he can identify. I think this section was just it should read that you can only bring the application after the persons whose will this is had died. You can't bring it before that. So it's not the person who had died that should have drafted the will. I just want to mention that if you execute a will, or if the will is invalid, remember what I said last week is then the trust deed is also invalid. And we do not recognize the principle of incorporation by reference in the law of succession. So you cannot refer to the trust deed. You must execute the trust deed. And if the will is invalid, then the trust deed will also be invalid. That's true. But then you can condone the document with the, say, for instance, some of the pages of the trust deed was not signed. Then it's a requirement that the document must be signed by the testator on all the pages. Then you can apply for condonation of the non-signing, because that's one. Thank you. We can move on then. I just want to stop for a second at revocation. I've mentioned is that you cannot bring an application in terms of Section 2.3 to revoke a will. The reason for that is revocation is not, there are no formalities for revocation as such in the Wills Act. We revert to the common law provisions. And in terms of the common law, there are two explicit ways that you can revoke a will, and there are also tacit ways in which you can revoke a will. But the most common way to revoke a will is by a later will with a revocation clause, or a later will with other provisions that in effect revoke the will. And then the problematic one is the destruction of a will. It's so easy just to go into the deceased study, open his drawer, find his will, or mine is in my laptop bag. I carry it with me because I want to amend it, but I don't get to it. And you can destroy it. And furthermore, one of the common law ways is you can ask somebody to destroy it on your behalf. Now, keeping in mind that you cannot cannot execute a will on behalf of somebody, but you can, in fact, revoke a will on behalf of somebody. And there was a case reported, was I can't remember now, I only saw it yesterday, where there was several requests while a person was in hospital with COVID, that he wanted to revoke his will, and after 4 attempts, he eventually passed on, and the will was not revoked. And the court ruled that because there was the later will, the testator didn't see the later will that was left at the ICU entrance to the hospital. He never had the opportunity to see it, therefore it was not a valid will, and therefore it was not revocation. But if you read Section 2A correctly, you will see the court has a power to condone certain methods of revocation. Not formalities, but either an indication on the will or on a document or an act being performed to the will. Now, the reason for Section 2A and 2B is because of uncertainty regarding certain informal ways of revocation of the will. The two ways is by a later will properly executed. So what if there's a document only indicating that you want to revoke the will? So, for instance, a suicide note. You want to revoke the will, but you didn't sign in the presence of two competent witnesses because you don't want people to witness when you are going to commit suicide. Can that be a revocation? And therefore, Section 2A makes provision for the court, if it is convinced of the intention, either from a document or from an act performed towards the will. Say, for instance, the testator jumped on the will until you couldn't read any words, or what action he can think of, typics, that was not known in the common law. Then the court can rule that this is a revocation. Coming back to the case of Becker versus Nordea, where there was a 2-3 application. Remember, if you have a 2-3 application and the document, which was not condoned in that case, is not condoned, then that document may be qualified in terms of Section 2A as a document not complying with formalities, so you are not applying for the condonation of formalities, but a document from which the court is convinced that the intention of the testator was to revoke that will. And the court said in Becker versus Nordea, there was no Section 2A application in the alternative to that application. Section 2B deals with automatic lapsing in case of divorce. There are also quite a few problems regarding that specific section, but there are now 2 cases reported on this matter after 35 years, no, 25, 30 years on this issue. Then we can move on. Thank you. I quickly want to go through this caution to be taken when drafting a will. Try to remember that one of the requirements is not only the formalities, it's also the testamentary capacity. The will drafter, when drafting a will, there must be knowledge of the different institutions that you can find in a will. There must be knowledge regarding certain specific clauses, simultaneous death clause like collation, amassing clause. What is the effect? What are the consequences of these legal concepts? What are the consequences of a fideicomissum or a usufruct? So, if you do not really know what you're doing, then obviously there might be problems when it comes to the administration of the estate and the interpretation of the will. Because if it's vague or impossible, whatever it might be, that it is not a valid will due to the fact that you cannot give effect to the will. Furthermore, the caution should be taken when you advise a person that you have knowledge regarding the limitations on freedom of gestation. Now, remember, freedom of gestation is very highly regarded. So, but in the new dispensation, unfortunately, it comes to a situation where the test for what is against public policy is no longer the test as it was when maybe you had executed the will in 1950 or 60 or 70. What the public policy is what is now, today, expected in terms of the Bill of Rights as in the interest of the public. So there are limitations, and the common law limitation is that a provision in a will should not be vague or impossible to execute and or against public policy. As I've said, the last one is in fact the most important one, because the principle there is what we also know, that a provision cannot be contra bonis mores, same as the public policy, public interest. So you cannot have a provision in your will that is sort of goes against the conscious or is offensive to certain people. Recently there were cases reported in Canada where a black man, disinherited his daughter. Expressly, he said it in the will because she didn't make contact with him for the past 8 years. But in fact, she had a child with a white man, and he didn't accept her or the child at all, and therefore it was found to be a racial exclusion and invalid against public policy. Also, a provision also in Canada where there was a provision in a will where a neo-Nazi group that promotes violence and hatred against certain groups, that provision in the will was found to be against public policy. In South African law, there was the recent case where the freedom of gestation was questioned in case of fideicomissum, the case of King versus de Jager. It's reported in the Constitutional Court under another name, but it was confirmed in the Constitutional Court's case, that where the state created a fideicomissum. I will come back to it quickly when we get to the fideicomissum. Created a fideicomissum for successive fiduciaries and fideikommissaries, and at the end, or the provisions of the will was that the fiduciaries at their death, it was immovable property, several farms, will go to their sons, and at the death of the grandsons, then it will go to the great-grandsons of the sons. And then one of the grandchildren only had daughters, 5 daughters, and they were not able to inherit. And they brought an application that this was, in fact, against public policy. It was discriminatory against them, and it was found to be the case, which means that the freedom of the gestation to leave his farms for several generations to only male beneficiaries was found to be against public policy. And there are a lot of trust cases as well that I'm not going to go into at this stage, where it was also found. The question is can the court change the trust deed in terms of Section 13 of the Trust Property Act, or is it against public policy and the common law public policy, or is it against Section 9 of the Bill of Rights? So a lot of movement regarding limitation. When you draft a will, there are also statutory limitations that you must keep in mind and advise your client about. That is, to mention a few, the Immovable Property Act. In case of a fideicommission, it can only be for 2 successive generations. The Trust Property Control Act, Section 13, if it's against public policy or there's the court can change the trust deed for a similar beneficiary. And very important is the Maintenance of the Surviving Spouses Act. Do not advise your client to point blank disinherit his wife. And if I say spouse, not wife, spouse, and if I say spouse, it is every person that is remotely regarded as your partner. This whole thing has developed into same-sex partners, opposite sex, same-sex in a marriage, same-sex out of a marriage, and now even to people who of the opposite sex who were not married are also entitled in terms of the Maintenance of Surviving Spouses Act to claim against the estate. And this is reflected as in your liquidation and distribution account as claims against the estate, or if there is accrual to you, it will be reflected. Or if you, you can't. If you are the deceased, you can't obviously claim in terms of the maintenance of surviving spouses. That will be important. Then we move on to the content of the will. The next slide. It is rather important to formulate a will and to give effect to what the testator's intention is. But remember that the testator might have something in mind, but it's not. He doesn't know what is the difference, for instance, between a fideicommission and a usufruct. But it's not necessary. You don't need to know the difference between the two. You don't need to use specific words like usufruct or fideicommission, fiduciary, but how the drafter is going to formulate the provision in that will, that will give effect to the intention, but it might not give effect to the intention. For that, the drafter needs to know the difference between the different institutions and the difference in the consequences. And how do you know what is the difference in the consequences? It's all about where the vesting of the rights will be after the death of the state. Now, most testators, especially more rich, that are more rich than others, the wealthy testators, want to keep control over the estate. I think people forget that once they are dead, they are dead. But it gives them satisfaction to know that at least, although he or she is not longer with the others, that the estate will be orchestrated in a certain way by his ascendants, whoever beneficial. Now, to create this sort of control, the most popular way to do that is by using a modal clause. Now, a modal clause is defined, I'm going to read it, as a qualification or obligation added to a gift or testamentary disposition whereby the person benefited is required to devote the property he receives or the value thereof in whole or in part to a specific purpose. So you keep, you expect of that person to do something or not to do something, to pay somebody, or to deliver something to another. In case of a modus or modal clause, the rights of the beneficiary vest, but not in case of a conditional provision. So if you say, I leave my farm to my son, if he obtains a degree in agriculture, then in that case, his rights will only vest once the condition is met. It differs from the modal clause in the sense that modal clause is you will leave something to, say, your estate to your son, and he must pay your daughter a certain amount on a yearly basis, annually. So what happened then is he becomes the owner, but subject to the obligation. And you will see that if he then doesn't comply because his rights already vested, then there must be restitution. But that's very difficult. Only when you read the will or see how it was distributed in the estate, you will realize where the vesting took place and whether it is a modal clause or whether it is a condition, or to go further than that, whether it's a fideikommissum or a usufruct. So there's a distinction between a modal clause and a conditional clause. Usually you find in the content of the will, there are just certain general provisions. And then once it comes to now you are going to appoint beneficiaries or legatees, then there is where the problem lies as to the. Now, the fideikommissum and the usufruct and massing are all modal clauses in effect. It will become clear as we continue, and you will see that the fiduciary will become the owner. In case of a usufruct, you will see that and it's expect of that person, of course, it's a modal clause, to do something. That is, a certain time it will move over to the fideikommissary, and then in case of a usufruct, the owner person, the ultimate beneficiary will become owner, but subject to certain limited rights of the usufructuary. And then in case of massing, elections should take place, and you must elect to comply with the modus on the created in the joint mass property. So if we move on to the next slide, I will explain the vesting of rights. But as I've said in the previous slide, it's rather important that the will draft has an idea of how to differentiate between a fideikommissum and a usufruct. And when there is massing, it usually is either a fideicomissum or a usufruct or other limited right, a year annual payment to somebody else or something. We'll see. I was asked to shortly just distinguish between the per stir base and the per capita provisions in a will. Obviously, the principles of per capita we only find in the interstate succession. In the interstate succession, there's also the provision that if you or that your descendants will inherit. If somebody is predeceased, he will be substituted the stir base by his descendants. And if there are any questions regarding the interstate succession, I can answer them later. To come to the testate succession and the drawing of the will, the testator is free to make provision for substitutes. If he foresees that, or she foresees that, for instance, somebody might be predeceased or will not be able to inherit, then the testator himself can use words to the effect, I leave my son, but if he's predeceased, it goes to his son. So it's either the one or the other one. It differs from substitution, fideicomissum, or fiduciary situation, where it's first the fiduciary and afterwards there's another person who is entitled to inherit. Direct substitution is either the one or the other. And once one has inherited, it is to the exclusion of the other person, the substitute that was nominated. But there's also now a provision in the Wills Act making provision for substitution in cases where it's not clear what the intention of the testator was. So, for instance, the testator didn't say a word, he nominated his son as his beneficiary, and now the son is predeceased. Section 2C2 makes provision that in cases where you were entitled to a benefit in the will of a person and you are predeceased, that your children will then inherit in your stead, except if the contrary is obvious from the will. If the testator said, my son, and if he cannot inherit, then it's my daughter. Then it won't be the descendants of that person. This is a phenomenon of direct substitution, because it's either the one or the other one. But what happened in both the interstate succession and in the estate succession is that in the interstate succession, section 1.7 of the Interstate Succession Act was added to the Interstate Succession Act to make provision not only for a person to be represented when that person is predeceased, but also when that person renounces a benefit or is unworthy to inherit. Can also be subject to section 1.6, which I'm not going to discuss here. Then in the testate succession, there's the provision in section 2C2 that when a descendant of the testator, that ad infinitum descendant, is predeceased or unworthy to inherit or repudiates his benefit, that benefit will go per stir base to his or her descendants, subject to Section 2C1, which is regards repudiation in case where the spouse and the descendant was nominated for the same benefit. Some people say in the same will. That is not very clear, but what I want to say is in case of statutory accrual, in Section 2C1, in other words, if one of the children of the deceased repudiates, that portion will go to the spouse, meaning any spouse, whether it's in terms of the Civil Union Act, whether it's in terms of the Recognition of Customary Marriages Act, whether it is in terms of the partnership bill or act that's coming up, or the new Marriage Act, new Marriage Act that is foreseen in the near future, any wife can then receive that portion that is repudiated. So that is the capita you find in the interstate succession. We have parental division in the interstate succession. If there's somebody in the first parental, that person will inherit. If not, then only you move to the second parentela. If there is somebody there, whether it is a sibling or descendants of a sibling or half blood siblings, then it will divide there. Also by what stirpays and representation will take place. But when there is no person in the first or second parentela that can inherit interstate, then you move to the third and fourth parentela, and then you get the principle of per capita division. And that means person in the nearest grade, nearest related to the blood related to the deceased will then inherit to the exclusion of others. So it means that your grandparents will inherit to the exclusion of your great-grandparents and your uncles and aunts. Okay, we can then move on to massing. Now, I begin with massing because when you discuss massing, then you will see that fideikommissum and the usufruct are limited rights, dealing with limited rights, and therefore massing will have the effect that you either have fideikommissum or a usufruct or annual fee that should be paid, but it's a limited right. So where do you find massing? How do we know what massing is? I refer you there to common law massing. That is a principle that comes from the common law. That is when people decide to put their assets together and to nominate certain beneficiaries. Say, for instance, a fideikommissum, they decide they are married out of community of property or in community of property, each owns half of the property. They put it together and they nominate the beneficiary. Now, what happened in common law massing is that when there was a usufruct or a fideikommissum, then there was no control over the first beneficiary, the initial beneficiary. And so, for instance, that person rented out the farm and they destroyed the whole, or the farm was burned down, or whatever the case there was a problem regarding the ultimate beneficiaries. So what the legislature did is they put in the administration of the Estates Act, there's a section 37, that deals with statutory massing. And statutory massing is limited to cases where there is a limited right, where it's not the same in common law massing. So we sort of not going to carry on with common law massing, because for us the question is, what if there is massing? Now you find the definition of massing in the section. It boils down to when two or more people in a joint will nominate beneficiaries, ultimate beneficiaries, over joint property. They put their property together, mass them into one. It can be all their property, or it can just be certain property. And then they give to the survivor or survivors a limited right. And the survivor must then, in fact, going back to the modal clause, must do something. The surviving spouse must let go of his or her property, of property, and that will go to the ultimate beneficiaries, subject to the limited right granted to the survivor. So he or she receives something, but there's an obligation to let that property go. After a while, fideicommisum, get the whole, you become the owner of the whole farm, subject to, at your death, it will go to the children. So what statutory massing wants to prevent is that the ultimate beneficiaries has no leg to stand on. And it therefore reads that when massing takes place, then the ultimate beneficiaries obtain the same rights towards the surviving spouse or surviving beneficiary as they have towards the testate, the first time. So if it's a fideicommisum, I will quickly move on, then you can see what is the difference and how the rights will vest. So massing is a joint estate. You expect of the survivor to do something. You give a limited right to the survivor, subject to complying with the provision will, and that has an effect on the ultimate beneficiary. It protects the ultimate beneficiary. That's what statutory massing is. So I've done the next slide, I think, going to the consequences. It's to protect the ultimate beneficiaries. What I didn't mention is, if there's massing, remember you must mass if the estate is massed, the surviving spouse still has the choice to adheate or to repudiate. If the person adheres, it means that that person cannot execute a later will dealing with those properties. You cannot revoke that will. You are then down to go with the provisions in the will. So we call it election, because you choose to either accept the provisions of the mass estate or to take your share, and you don't inherit from the co-testator. Okay, we can move on from there to the fideicommisum. Everybody knows, in effect, what a fideicommisum is. it is you leave your property to somebody subject to after a certain time, certain condition has been fulfilled. Say, for instance, the testator when the survivor remarried, then it will go to another one. There are statutory limitations. It's restricted to 2 subsequent generations that you can create such a fideicommission. There is a presumption against a fideicommission in favor of direct substitution, because in case of direct substitution, it's either the one or the other one. So there's not a limitation of rights. So can we begin on? The next slide. So sometimes there's a problem regarding the fideicommission. I refer there to the tacit creation of a fideicommission. That is a clause like, I leave my farm to my son. If he dies without children, it goes to my daughters. So then the question is whether there is a fideicommission created in favor of the children who is referred to in the provision. What's more important is the nature of the beneficiary's rights and how massing impacts on that. The fiduciary becomes the owner, but his ownership is limited. It's limited in the duration, and it's limited that he cannot alienate the immovable property. The fideicommissory only gets a vested right, personal vested right, against the executor, for seeing to it that at the end of the fiduciary's rights, that he becomes then either the owner, also subject to a further fideicommission, or he also has a personal right against the fiduciary to not act contrary to the provisions in the will that created this. So you can see it's a form of a modal clause, and it's a form of massing. If there is joint property, it's massing. The fiduciary has a limited right. Why? Because he cannot alienate the property, and after a certain time, it is suspended his vested rights, and the ultimate beneficiary, the fideicommission, he gets a personal right against both the estates if there is a massing. The fideicommission residue is a situation where the power is given to the fiduciary to use the property as he or she wants. There is a restriction, a common law restriction, that 3/4 of the property can be used, but at least a quarter must go to the fideicommissory. So you say you provide for the fiduciary that he can use the assets as he wishes, subject to the common law provision, or if there is what we call boedelhouerskap, that's a situation where the spouses, and you give to the spouse the right to alienate the property or use it or whatever, then there's no restriction on when it's boedelhouerskap. It's just as if the surviving spouse continues with the estate, and what is left of that, if any, will then go to the fideikommissaris. Then the what slide are we now? The next slide, I think, is the group. We know about the statutory limitations to subsequent. I will discuss some of the cases if there is time. I think we are running out of time. I just want to go to the usufruct first and the difference between the usufruct and the fideikommissum. The usufruct as the fideikommissum are very popular institutions, and although from estate planning point of view, you can rather create a trust, although we heard about the problems with the testamentary trust last week. This is where you nominate, once again, ultimate beneficiaries, and they become the owner or owners of the property, but subject to the use and enjoy of the fruit of this this benefit by somebody else. So you can leave your farm to your children, subject to, remember, this is also a way of control by the testator. So you leave your property to your children, subject to the usufruct of by your wife, or you leave your farm, for instance, to your grandchildren, subject to the use of children or your parents or whoever. Now, how do you know whether it is a usufruct or a fideikommissum? It is a fideikommissum when the institutus, the person, the fiduciary, becomes the owner. In case of a usufruct, the usufructuary can never become the owner. That person has a real right, a limited real right, but the dominion of the ownership of the property goes directly to the ultimate beneficiary. So it's only the use and the fruits of the benefit that goes to the usufruct. So the ownership is not with the usufructuary. In case of the fideikommissum, the fiduciary can become owner if there is no fideikommissaries alive. But the usufructuary can never become the owner, because the ownership already is with somebody else who has the bare dominium or the nude dominium, and they will then be the owners. So when you go then to court cases and you read what is created, then often it's not clear what was the intention of the testator, because the wording, you don't need to use specific words, and the wording has the effect that it can either be the one or the other one. The same with direct substitution and fideikommissum. It's obvious, sometimes it's a combination of the two, and it's not clear what exactly is the first one going to inherit to the exclusion of the other or not. And in the case of the usufruct, if there is an indication that the institutus, the first person, will become as vest ownership but limited ownership, then it's a fideikommissum and not a usufruct. If it's clear that the institutus becomes owners subject to the use by somebody else, then it is a usufruct. Just see if we can move slides. The vesting of rights I've already explained. The usufructuary has limited interest over the movable or immovable assets. It belongs to somebody else. The usufruct includes the capacity to occupy, use, enjoy the property, and take its fruits. And the holder of the bare dominium is the ultimate or eventual owner of the property, but his rights are limited. And if we go back to massing, massing is when the two people make a joint will in which the survivor receives a limited right subject to relinquishing his or her portion of the estate. So if it's massing, you can say, leave our farm to our children, subject to the usufruct. Then the survivor must elect whether she wants to, say, for instance, it's the wife, whether she wants to let her half of the massed estate go to the ultimate beneficiaries, subject to the fact that she will receive a limited right on the whole, her share of the property as well as the first estate. So I didn't get to all that I want to say, but I think I said enough. Thank you.
Thank you so much, Prof. We really appreciate it. Very interesting. The first one is from Mr. or Mrs. West. I can't see clearly. With regards to the validity of a will, we have experienced where certain pages of the will was original and some pages were photocopies. What would be proposed the solution be? So in other words, there's a will, some of it's original, some is copies. Is that acceptable? Or if not, what's the outcome of it? How do they go about to fix that?
I think what you will do is you will apply in terms of section 2.3 to condone those pages that were not signed, as if they were not signed. And then the court can find that that there is non-compliance on those pages and that they condone it. Strictly speaking, you cannot condone a copy of a will. There's another procedure to follow, and that is a common law procedure where you have to prove that the will, what happened to the will, why is there only a copy, that the copy is in fact the same as the original will, say that's now missing. But I think the only solution here will be to apply that the will with those 2 pages, photocopy pages, be condoned on the basis that it is an invalid will because it does not comply with the formalities. Those 2 pages were not signed. The whole will must sign as one. Otherwise, only the pages that were signed will be valid. But if it doesn't make any sense, then that cannot be the situation. My guess is that the court will condone it. Of course, the courts do not really know that you cannot condone a copy. So I think they will condone it, but on the basis that those pages do not comply with the format.
Thank you, Prof. The next question is from Mariska. She says, joint wills and massing often create confusion. She says, does a joint will always imply massing? I think I can quickly answer it. Definitely not. It depends on the wording of the will. Then a second question she asked, does a joint will in all circumstances imply once made between 2 parties that is irrevocable once one party is deceased? definitely not, Mariska. You can always amend the will after the first dying pass on, obviously, and the surviving spouse. In the case of a married couple, the surviving spouse can change. Then Johan van Heijsteen, presentation, clause 6.1. In the case of a usufruct, may the testator give a right to income of the specific asset to a legal person, like a business or a trust company. Let me go to number 6.1. Mariska, I think you need to take into account that the ultimate authority in South Africa over children is the High Court. So ultimately, the High Court will make such a decision. All right, I think we've covered all the questions. Thank you so much, Prof. We appreciate your time. Thank you, everybody, for attending. May you all have a wonderful week.